A federal high court in Abuja has reserved judgment in a suit filed by two aggrieved directors of Green Energy International Limited against the chairman, Professor Anthony Adegbulugbe. Justice Bolaji Olajuwon took the decision after counsel to the parties in the suit adopted their processes and presented their argument. She said the judgment date would be communicated to the parties. Olajuwon also reserved judgment in a suit filed by the oil and gas company and Adegbulugbe against the two directors, Dr. Bunu Alaibe and Mr. Ayo Olojede. The development followed the breakdown of peace talks between the directors and the company's chairman. The news agency of Nigeria reports that Adegbulugbe was a former special advisor on energy in the Olusegun Obasanjo administration. Alaibe and Olojede, two directors in the company, had sued Green Energy and Adegbulugbe as first and second defendants. The plaintiffs in the suit, which commenced via a petition, accused Adegbulugbe of series of corporate illegalities, including unilateral usurpation of executive responsibilities contrary to the provisions of the Companies and Allied Matters Act 2020 and the company's articles. They claimed that they were unlawfully removed by the chairman of the company, which they jointly nurtured. Responding, Adegbulugbe also filed a separate suit against the two directors before the court. The parties indicated interest to settle the dispute out of court, prompting the judge to adjourn for report on the out-of-court settlement or for continuation of the matter. Upon resumption of the first case filed by Alaibe and Olojede, counsel to the defendants, Bembela Anichebe-san, told the court that the settlement process had broken down. He said since the case was adjourned for report of settlement or hearing, he was ready to proceed with the hearing. Adeyinka Aderemi, who held brief for Etuge Wasan, however, said settlement was still ongoing as the terms of agreement were being responded to by Professor Gbolohan Elias, who was engaged to draft an interim agreement. He said only two issues were outstanding, including the payment of salaries of the petitioners, the two directors, adding that Elias had promised to revert to the petitioners. But Anichebe insisted that in the letter written by the directors to Elias, they categorically rejected the proposal. He said Bunu and Olojede wanted their salaries to be paid first before the issue of settlement was addressed. He told the court that the duo had consistently rejected the draft agreement. Anichebe said once the pending motions had been served on parties, he urged the court to allow them to take the applications and move on. But Aderemi restated that the last response from Elias, as at June 14, was that after confirming receipt of their letter listing those two demands, he promised to respond. Responding, Anichebe insisted that no salary would be paid until the terms of settlement was concluded. He argued that the petitioners must sign an interim agreement for them to be paid salaries. Following the argument by counsel to the parties, Olajuwon, the judge, consequently ordered the parties to take their applications. While Anichebe urged the court to dismiss the suit filed by the two directors, Aderemi prayed the court to grant all the reliefs sought by his clients. After parties adopted their processes and presented their positions for and against the suit, the judge reserved judgment in the matter. She said the judgment date would be communicated to the parties. Also, in the suit filed by the company and Adegbulugbe against the two directors, Anichebe informed the court that having indicated interest to withdraw the suit, he urged the judge to strike out the matter. He said the case had been overtaken by events, but Aderemi, in his argument, prayed the court to dismiss the suit rather since issues had been joined in the matter. Olajuwon, the judge, equally reserved judgment